Good afternoon. My name is Aurélien Lorange from the Quarks Foundation, and with Mr. Urbanova, we'll be having the day 3 match, the third match, between two teams who are in the group A. We have Tallinn University of Technology in Tallinn, Estonia, and we have as well Jigme Singye Yuanchuk School of Law in Paro, Bhutan. And these two schools will be debating on topics they received a week ago, 7 days. But of course, before we jump into that topic and the debate after that, let's just give the floor for the introduction, of course, of the debaters. So I would like to give the floor first to Sonam Hujiayong, Laden in Bhutan.
Hello.
Hello.
My name is Sonam Hujiayong, and I am a undergrad at JSW School of Law, and we are very excited to do this match today. We're very excited to hear what our opponents might have to say, and I wish everybody a great success.
Thank you very much, and welcome. We have as well Juho Ilsirnieu. Welcome.
Yes, thank you for the warm welcome. Yes, my name is Juho Ilsirnieu, and I'm a second-year bachelor law student, and I'm hoping to have a great debate with this exalted team.
Thank you, and welcome. We have as well in Bhutan, Eiden Dema. Welcome.
Hello everyone, I hope I'm audible and visible. My name is Eiden Dema and I am also pursuing my undergrad at the Jigme Singye Yuanchuk School of Law. I wish everyone an amazing debate ahead and we are very excited to participate.
Thank you and welcome. We have as well in Tallinn, Luka Shkilatse. Welcome.
Hello everyone, my name is Luka. I'm from Georgia, but currently studying in THIULDT on my master's degree in law and technology, and I hope everybody will have a great time, and I wish you all the good debate.
Thank you and welcome. We have as well in Bhutan, Kinley Yongdon.
Hello everyone, my name is Kile Youngdon and I'm 20 years old and I'm a second-year law student here at JSW School of Law, and I'm very excited and looking forward to a wonderful match with you guys. Thank you.
Thank you very much. And in Tallinn, third member, Joseph Blaine McPantai. Welcome.
Hello everybody, I'm a Filipino student here in Tallinn. I'm currently doing my first years in law here in Tallinn University of Technology. I'm looking forward to this debate with all of you today, and hopefully we can get to know some important things from this motion as of today.
Thank you and welcome. And we send greetings, and we have even some coach. To the coach of the two teams. So I would like to start with Mr. Leki Chering.
Hi everyone. I'm Leki Chering. I am one of the team advisors for JSW School of Law, Bhutan. We're really excited and looking forward to the match. Wishing both teams all the best.
Thank you, and thank you for connecting from the US, where you are currently very early over there. And as well the second coach in the room, Ashish Gurung. Welcome.
Hello everyone, I'm Ashish Gurung and I'm one of the team advisors for the JSW School of Law, and I would like to wish both the teams very best of luck.
Thank you, welcome. And as well we thank the third member, Pema Shoki, of the coaching team for Bhutan. On the side of Tallinn University of Technology as well, we thank as well Alexi Oscar Johannes Kayander, the coach of the TELTEC team. The topic which was sent a week ago was emerging data protection laws regarding blockchain technologies must favor individual rights over immutable transparency. So now I will share my screen. So we'll do, of course, the allocation of positions. So is it visible? I'm not always sure if you can see on WebEx.
Yes.
Yes.
Ah, okay. So, so as you can see, there are two possibilities for the two institutions, so that even, sorry, to be in favor or to be against. So the team will be in favor, will be starting the match with the first introduction. So for this match, Tallinn University of Technology will be in favor of the motion, and will be starting the match with the first introduction. It means Jigme Singye Wonshuk School of Law will be defending the position against the motion. Concretely, Tallinn University of Technology will defend the position that emerging data protection laws regarding blockchain technologies must favor individual rights over immutable transparency. Jigme Singye Wonshuk School of Law will defend the position that emerging data protection laws regarding blockchain technologies does not have to favor individual rights over immutable transparency. So now you will have 5 minutes to review your notes, and then we hear the introduction by the team from Estonia.
Thank you very much. Your time for final preparation has now passed. Before we start to hear the opening statements, just a short reminder, you will get visual cues as to your time, yellow for 30 seconds remaining and red for the speaking time being up. Of course, comfortably conclude your last sentence. And thus, without further ado, for the 4 minutes of the opening statement, Tallinn University of Technology, you have the floor.
I'll be beginning in 1, 2, and 3. Honorable judges, the blockchain technology was created around one single core aspect, immutability. Once the information is stored on a chain, it cannot be easily deleted or changed. This creates trust in the digital society, but also conflicts with legal innovations. Modern data protection is built around individual rights, which defend our dignity and our privacy. But when those two principles conflict, the question becomes simple. Which value should prevail? Our team line is clear. Individual rights should prevail over immutable transparency. We argue by 3 main points. Data protection is a fundamental right, right to erasure conflicts with blockchain, and protecting privacy builds sustainable innovation. If we look at data protection, it's not just a policy, it's already a fundamental right. For example, the Article 8 of the Charter of European Human Rights of European Union guarantees the protection of personal data. If we look at GDPR, General Data Protection Law, it gives clear rights to the natural beings, right to access personal data, a right to erase certain data if the conditions are met. These rights protect human dignity, autonomy, and privacy. If a technology locks personal data into an immutable ledger, and those rights become impossible to exercise. So why should we have the law if it's impossible to exercise? The answer is clear. Fundamental rights cannot depend whether technology can or cannot comply with the fundamental rights. Therefore, it must adapt. Argument 2. The right to be forgotten is one of the core legal principles of GDPR and the most important right in mentioned regulation. Because if we look at the case law, Google Spain versus AAPD, we see that the right to be forgotten is a exercisable right, and information that is in search results can be erased if the center conditions are met. But if we look at the blockchain system challenges this principle because data written there cannot be easily deleted. The legal rights do not disappear because the technology makes a compliance difficult. If blockchain systems process personal data, developers must develop in a way that personal data is encrypted or data is minimized or privacy preventing architectures are built in there. Law defines the rules of society. Technology must always comply with law. Argument 3. Protecting rights is not bad for technology, it's better for them. Because some argue that it limits blockchain transparency and will harm innovation, but opposite is true. Technology that ignores law cannot survive long term. We already see companies all around the world recognizing the personal data and building their systems around it. Therefore, systems that ignore individual rights will face regulations, fines, lawsuits, and public resistance. Because data protection is fundamental right, because immutable systems conflict with blockchain, and because the sustainable innovation requires trust and legality, we finish up our opening speech. Thank you.
Thank you. For the opening in the against position, University, you have 4 minutes.
Am I audible and visible?
You are.
Thank you. Then I shall begin my opening statement in 3, 2, and 1. Esteemed judges and respected opponents, Blockchain has finally given society what corruption fears most: records that cannot be erased. We stand for upholding this transparency because the public's claim to the truth must never be weaker than a single claim of privacy. For this, we have three arguments. Number one, access to information. Number two, we have prevention of corruption. And number three, we have financial crime regulation. So number one, international law has noted transparency as a crucial aspect of public accountability and oversight. Article 19 from the International Covenant of Civil and Political Rights mandates that individuals have the right to both receive as well as seek information. And because of this is complemented by Article 10 from the European Convention of Human Rights, which maintains this right to access information. Furthermore, in the case of Magyar Helsinki versus Hungary, the European Court of Human Rights has affirmed that the access to information held by public entities is a crucial part of public accountability and oversight. Blockchain does exactly that. Its immutable ledgers provide transparent information for relevant authorities at the right time. If this was not done and law started favoring individual rights, then public accountability mechanisms like this would collapse. Now, second, let's talk about prevention of corruption. The United Nations Convention Against Corruption, Articles 9, 12, and 14, mandate states to come up with systems that upholds the principles of accountability, transparency, and oversight, prohibiting corruptive practices. And because of these legislative systems, we have to ensure that the immutable transparency is always upheld above individual rights. Let's take a look at the country of Georgia. In the country of Georgia, land registry is linked to blockchain technology. In a country where frequent document manipulation and land disputes were common in the past, nowadays this is a thing of the past and the law has become much more certain. The processing and the certainty of these legal documents has also become much more consistent. And as a result of this, we should uphold this immutable transparency. Now let's move on to the third one, which is financial crime regulation. In an era where where money laundering is so rampant, it is important for immutable transparency to be available to catch these culprits. The most important legal instrument for this, the Financial Action Task Force, mandates states to come up with systems that allow relevant authorities to track transactions across systems, and states enabling relevant authorities to investigate suspicious cryptocurrency transactions and capture these culprits. If this was not done, then these criminals would right away scot-free. And as a result of this, such crimes such as money laundering and terrorism funding would become even more rampant. Now let's look at the example provided by the FBI. So in 2021, there was the Colonial Pipeline ransomware attack. And during this time, the FBI was able to recover millions lost in ransom payments during that time. And it wouldn't be possible without the immutable nature of blockchain technologies. And as such, we oppose the motion that individual rights should be favored over immutable transparency. Transparency should be favored, and the state's interest, the public's welfare at large, should always be given much more importance than a single claim of privacy. As such, we oppose the motion once again, and thank you.
Thank you very much. We'll now proceed to hear the rebuttals. Tallinn University of Technology, for the first in favor, you have 2 minutes.
Hello, am I audible?
You are.
Okay, I'd like to begin. In 3, 2, 1. Panel. ICCPR Article 19, in fact, does give people the right to seek and receive information. However, one key critical part of this article in general is one of the limitations to this article. This limitation specifically states, this shall not apply in case of breaches to the rights of others. Meaning, if we are to go down the route of immutability, or rather, if we are to go down the route of pursuing immutability, we would be violating the very key principle that the opposing team has told you, hence of today. And that is, we cannot sacrifice immutable rights for crime prevention. I'll be tackling two rebuttals. Firstly, the accountability mechanisms our learned opposition has already told us of before. Yes, we do believe that accountability mechanisms should exist, and they exist in a great wide variety, not just through the accountability mechanisms of blockchain technology. Because blockchain technology as a whole isn't widely used by a vast majority of people, and traditional banks with court orders, police and law enforcement can already get information from these traditional sources, which is vastly used by a wider majority of people. Secondly, we have their entire argument on corruption. Whether or not you may say that, well, since criminals use these sources, it would be better off for us to prevent them from using them as a whole. However, we need to think in the mind of a criminal to begin with. If they were to find out, and they will definitely will so because the companies will announce that it's no longer immutable, they will no longer use blockchain technologies once it has been passed to prioritize individual rights. They will develop their own means of communication, making it harder for law enforcement to track as a whole.
Thank you. For the first rebuttal in the against position, Jigme Sigmeo Wongchuk School of Law, you have 2 minutes.
Am I audible and am I visible?
You are.
Then I shall start in 3, 2, 1. Honorable judges, in response to the proposition's arguments, we have 3 rebuttals. First, now the proposition has elevated individual rights as a legal absolute that prevails over all other needs. However, no treaty, custom, or general principle establishes that individual privacy automatically prevails over transparency. Under the ICCPR, privacy can be limited where interference is lawful, necessary, and proportionate. The European Court of Human Rights confirmed this balancing approach in SN Marper versus United Kingdom. So while the proposition stance may be true in isolation, the full picture tells a very different story. Article 6(1)(f) of GDPR permits the processing of personal data without consent, where processing is necessary for the legitimate interest of the controller or a third party. Second, the proposition has introduced restrictions on individual data control as if it's something new. However, data protection law already recognizes limits to individual control. Under Article 17(3) of the GDPR, the right to erasure does not apply when processing is necessary for compliance with legal obligations, reasons of public interest, or the establishment or defense of legal claims. So where the proposition has offered assertion, we have offered proof. And lastly, the proposition believes that transparency is a slippery slope that directly leads to surveillance and violation of individual rights. Transparency does not automatically mean unrestricted surveillance. Article 8(2) of the European Convention on Human Rights permits interference with privacy when it is necessary and proportionate for legitimate aims such as preventing crime or protecting the rights of others. Similarly, the GDPR Article 32 requires appropriate safeguards. Therefore, while we are happy to rebut what the proposition said, we cannot rebut what was merely implied. Thank you.
Thank you very much. For the second rebuttal in favor, Tallinn University of Technology.
Am I audible?
Yes.
Okay. I'll begin in 3, 2, and 1. Panel, we find it a little bit baffling considering that we already cited a source where individual rights are prioritized over the right for information. And it's the very article that team opposition throughout this debate has been claiming is super important. And that's ICCPR Article 19, everybody's right to seek and withhold information, right? However, we already did claim that this specific article has the limitations. That limitation is with respect to other people's rights and reputation. Clearly, it already outlines and responds to their argument on, well, it doesn't necessarily, there are no legal orders that give the priority of individual rights over transparency. Well, if the very article and the very document that team opposition throughout this debate clearly says that this limitation exists, we don't believe this is a valid argument. Secondly, when it comes to prevention of crime, yes, we do believe this is a highly important mechanism, and blockchain technology as a whole, we acknowledge that it is already being used for a majority of criminal activity. However, we do bring up the fact that once this inevitable shift happens, once this shift happens that team opposition tried to tell you, it will no longer be the case that criminal people will be using blockchain technology as a whole. They will seek alternatives for their transactions, which ultimately makes it harder for law enforcement to track to begin with. Because if you are in mind of a criminal and you know that this technology is no longer mutable, why would you use it if its main purpose has already been eliminated? It will only lead these criminal organizations to create new means of transactional opportunities, and these new means of transactional opportunities will be much harder to track for law enforcement because now it is going to be through an underground measure, no longer through the public eye and the public lens that happens in the status quo.
Thank you. For the second rebuttal in the against position, you have 2 minutes.
Am I audible and visible?
You are.
Thank you. Then I shall begin my rebuttal in 3, 2, and 1. Esteemed judges, the opposition's misconception that blockchain cannot comply with privacy laws is based on an oversimplified understanding of how it actually works. In Google Spain versus AEPT and Mario Costia Gonzalez, the CJEU established that controllers must take all reasonable measures to approximate erasure, not that literal deletion is always required. Moreover, GDPR Recital 26 reinforces this, providing that data protection principles do not apply where data is rendered truly anonymous and the individual is no longer identifiable. Blockchain systems satisfy both standards through off-chain storage and encryption, proving that immutability and privacy can coexist. The opposition also ignores the legal repercussions of implementing a system that overwhelmingly favors individual rights. It would undermine the legal certainty and third-party reliance that blockchain exists to provide. UNCITRAL model law on electronic commerce and related instruments recognize the legal validity of electronic records and signatures. Blockchain records are now being increasingly tendered as evidence in arbitral and judicial proceedings. The opposition has also made the claim that if we implement immutable transparency, then these crimes would simply go underground. Well, I would like to turn over that statement and say that just because this is a possibility doesn't mean that we should start favoring the individual rights and stop immutable transparency as a whole. A partial solution is still better than doing nothing at all, isn't it? And as a result of this, it is always better for information to be accessible, transparent, and available to the public and relevant authorities at all times. And as a result of this, we oppose their points, and I rest my rebuttal here. Thank you.
Thank you very much. We'll now proceed to hear the concluding statements. Tallinn University of Technology, 2 minutes.
Hello, am I visible and audible?
Yes.
All right. I shall begin my closing in 3, 2, 1. Honorable judges and to our exalted opponents, we commend you for arguing your case with genuine conviction and passion. However, let us be honest about what this debate truly is about. This debate is not merely about cryptographic hashes or pseudonymous wallet addresses. This debate is about people, real people, whose medical histories, financial struggles, and personal mistakes could be permanently written into a ledger they never consented to and can never escape. Imagine a person who made a financial mistake in their youth. Under blockchain immutability, that record follows them forever. No correction, no erasure, no second chance. The opposition calls this legal certainty. We call it a life sentence for data. The opposition argues that this falls within acceptable limitations. And while we certainly agree that there is a need for balance, but what does balance look like when one side holds a corporation's interest in an immutable ledger and the other side holds a human being's right to dignity and privacy? In our opinion, that's not a close call. Technology is always adapting, and we welcome that. But adaptation cannot be voluntary and indefinite. The law must set the standard. People cannot be asked to wait while developers slowly catch up, their personal data exposed in the meantime. So we ask you this: if we cannot trust the law to protect people from systems that hold their most personal information, then what exactly is the law for? Fundamental rights are not negotiable. They're not inconvenient obstacles to innovation or inconvenient obstacles that prevent police from catching financial criminals. They are the foundation upon which any legitimate technology must be built. The proposition stands not against technology, but for the people technology was always supposed to serve. And we believe these people have to come first. Thank you.
Thank you. Thank you for your statement. Jigmesinge Wangchuk School of Law's team, you have 2 minutes for your conclusion in the against position.
Am I audible and visible?
You are.
Then I shall begin in 3, 2, 1. Honorable judges, one question. Should we let anyone erase records if it means criminals and corrupt actors could go unpunished? The answer must be no. For centuries, selfish, powerful actors have manipulated records, erased evidence, and rewritten history to escape accountability. But blockchain offers something extraordinary. A system where the truth cannot be quietly altered. It gives the public something they have rarely had before: evidence that cannot disappear. But if data protection laws allow individuals to erase records whenever transparency becomes uncomfortable, we risk returning to the same world we have tried to escape. A world where the powerful can simply make the evidence vanish, and when evidence can be erased, justice is not just delayed, it is denied altogether. Transparency and access to information are protected under Article 19 of the ICCPR and Article 10 of the ECHR. Blockchain strengthens these rights by preserving immutable records while also supporting obligations under the UN Conventions Against Corruption and the FATF standards to transparent and traceable financial transactions. The opponent's approach risks giving individuals control over records that must remain public, and that is just putting personal choice above the rule of law. Our side defends immutable records for audit, not tampering, enforces transparency, not concealment, and ensures traceable records and not loss of accountability. Privacy is important, but so is accountability, and so is the public's right to know. The law should never become a tool that helps the powerful hide the truth from the very people they govern. So, honorable judges, rule against the motion, and you send a clear message that immutable transparency and accountability cannot be compromised and that we will choose traceable records over erasure that could hide wrongdoings. Thank you.
Thank you. Thank you for your statement. You can all now relax. You are no longer graded after this part. And you have successfully concluded your day 3 match and your group phase for the 2026 edition. Well done, really well done to your teams. Your debate now is the second day 3 debate of this week. So you are in a good stretch. As in the previous days, the judges have the time to review the match and submit the scoring cards. But we would already like to invite you to share your impressions of the topic, of the exchange today, perhaps for the research, and if you're familiar with the topics already, starting with the Jigmesinge Wangchuk School of Law, perhaps Ms. Ladhan.
Hello once again. So, to share my thoughts on today's topic, I would say that I was quite surprised at first because, like, since blockchain and AI are like still, I would say their legislations are still in the development phase. It was like an unexpected one for us. We have really not like encountered this topic in depth in neither our courses nor in the like interactions, discussions, and lectures held by our institution. But nevertheless, we had a lot of fun researching for it. All of my teammates and I, we had a great time searching for the emerging laws. It was new knowledge for us, but nevertheless, it was interesting.
Thank you. Thank you very much. And now we'll ask as well the members from Tallinn University. So Mr. Euro Ilsirnieu.
Hello. Yeah. I thought this debate went well. I really enjoyed debating against the amazing team from Bhutan. In my opinion, they were just phenomenal, and I love their background as well. It looks very nice. But yeah, I definitely this was a very intriguing one because I'm like to confess I was not very familiar with blockchain technologies before having to do some research for this debate. So I definitely enjoyed learning a lot, and it felt very nice to be able to apply that knowledge from the research as well.
Thank you very much. Now back to Bhutan. I would like to have the opinion from Sonam Jueong Laden.
Hello, am I audible?
Yes, you are.
Just like my teammate Yudin shared, this was a new topic for us, but like she said again, we had a lot of fun researching and forming arguments. And despite the fact that we hadn't encountered it in our courses before, I believe that we rose up to the occasion magnificently without sounding too proud or conceited. And I believe that was largely due to not only our team effort, but because of our coach advisors, of course, as always. Thank you.
Thank you very much. Same question for Mr. Joseph Blaine McPantai.
Hello. For this debate topic, specifically as somebody who comes from the same region as our learned opponents, it was a very similar experience of not really having much of a background in such a topic, and it was very insightful and very fun to look into such a topic. Actually, so much so that I've more or less tried to consider looking into this topic of financial crimes and blockchain technology in my future career, hopefully. And yeah, it was a very fun debate, specifically being able to engage with such learned opponents. So thank you so much for such an opportunity, and thank you for doing so well for our opponents.
Thank you very much. And now back to Bhutan. I would like to ask Miss Kinley Yangdon.
Hello, am I audible?
Yes, you are.
To answer that question, like my seniors here have mentioned, the topic was fairly new to us, though we have heard of blockchain and cryptocurrencies before, but we have never looked into it in this much depth. And so we had a lot of fun doing the research, and we would really like to thank our coach advisors as well for helping us throughout this journey. And like the opposing team mentioned, this was a very wonderful debate.
Thank you very much. And now a question for Mr. Luca Shkiladze. Mr. Shkiladze, yes?
Hello.
Yeah.
Sorry, had some problems with the internet. Thank you all for the great debates. I found it very challenging because the opposing team was also very good. Let's wait for the results. Yeah, and the theme as well was quite close to me because I now work in this field. So maybe I had a little bit advantage, but the other side also proved that there are no advantages or disadvantages in our debates, and wish them good luck in the future. Thank you.
Thank you very much. Now I would like to ask some coach who are in the team, in the room, WebEx room. So I would like to see if Mr. Cheering can tell us what he thinks about this match.
Am I audible?
Yes, you are.
Yes. So yeah, like most of the participants said, this topic is also something very new to me. For me, I'm specializing in the environmental energy law, so blockchain, AI, cryptocurrency are something that goes over my head most of the time, and I've never had the opportunity to research in depth on these topics. But having worked closely with my team and also listening to the arguments from the team from Estonia, it's been very enlightening, I'd say. And I'll definitely say that both teams did really well. It really showed the hard work and the efforts both teams have put in. So all of you should be very proud of yourselves for working hard and coming this far, regardless of what the results are going to be, whether both the teams advances or not, right? So you guys should really be proud of yourselves, and all the best for the future. Thank you.
Thank you. Thank you very much. So now we are done with the feedback time, so it will be the moment to finish with some more information from the debaters, especially because it's the third match. So it means now they are wrapping up with the group phase. But we can still ask a few information about them because yes, after the competitions probably there will be as well think about the next year, the studies, etc. So my first question, which will be addressed to each team, and you can decide who want to answer first, of course, will be if you want to thank some persons who have been encouraging you during these 3 days of match, these 3 match that you got. So if there are some persons, some let's say maybe faculty, friends, of course the coach, student association. So who should be those persons? Maybe former participants as well. So we start with yeah, in Estonia. So who wants to start answering who you think you should give a shout out to?
Hello.
Yeah.
I'd like to start with, of course, our coach Alexei. He's currently, I believe, on his way to Japan right now, but without his help and without him helping us throughout the practice debates and coaching us throughout the couple of weeks preparing for these debates, we definitely wouldn't have done as well as we did. So a very big shout out to our coach Alexei, even in the moments where we were just having fun after the practice debates. Very enjoyable time because of him.
Thank you. Mr. Ilsirnieu, or yeah?
I would like to just add on to that. Yeah, I agree. A big shout out to Alexei for for being there for us, and I'd also like to shout out the ILSA team here at Tallinn University of Technology. They've also been very kind to us in these times, and yeah, just we have a lot of appreciation for them and for the coach as well.
Thank you. Greetings to ISA Taltech, indeed. And Mr. Shkiladze.
Yes, sorry, I couldn't hear the last part. Could you repeat?
Yeah, sure. Who would you like to give shout out to? I mean, for the support.
I would like to give a shout out to our coach because he was the one that motivated us the best, and also his real passion to train us, and he's always cheering for us. And yeah, we become better debaters from each debate because our coach makes sure that we learn from our mistakes and we also enhance our good sides. So yeah, I would like to give a shout out to Alexei, and I hope that we will continue in this tournament to work with him as much as we can. Thank you.
Thank you. Thank you very much. Now, same question for the team in Bhutan.
Hello, am I audible and visible?
Yes, you are.
Thank you. So regarding the shoutouts, there are just many individuals who have been such an amazing and crucial part of our journey during this debate. But I would say that the most important people would be our amazing coach advisors. They are Mr. Lekitsring, Mr. Ashish Kurung, and Ms. Bemochiki. They have been an amazing set of advisors, the best team of advisors that we could have ever asked for. They have not only given us the support for the more technical aspect, but they have also provided us with the much needed emotional help as well, because this opportunity is such a new thing for us. It has been a little bit daunting as well. So they have been an amazing, crucial part of this, and we will never forget their kindness and care for us during this amazing journey. So we would also like to shout out to one of our visiting faculty members, Professor George, who has provided us with much needed comments on our delivery aspects and give us a lot of like comments onto how we can improve and sound more like assertive, persuasive, you can say so. So in this manner, this amazing like I would say team of people have like raised us to this level. Even if we are the participants, they will always like shine through us. That sounds cheesy, but yeah, that's the truth.
Thank you. And maybe your colleagues would like to add something as well.
Like my teammate just mentioned, I think the persons that we have to thank the most would be our coach advisors, and of course, our visiting adjunct, Professor George. He was invaluable in giving comments on not only our delivery aspects, but also our substantive arguments as well. And besides that, of course, our friends have been a great source of comfort during these hard and trying days. And I think all of them have been a great source of not only comfort, but encouragement to us as well. They made us believe that we could do this, that we can keep doing this. So yeah, thank you.
Thank you. Miss Yangdon, you want to add something? Or...
Hello. So, like my team mentioned, we have so many people to be thankful towards. Coach advisors, most importantly. Then we have Professor George and our friends and families. But I'd also like to thank our institution for providing us with this opportunity, and the Corex Foundation itself for providing us with this wonderful platform to showcase what we have been working on so far. Thank you.
Thank you, and thank you very much. It's a pleasure to have had the two teams having those three matches. Of course, it's not finished, but that was really a pleasure to see the progression as well through the group phase. So I think we are now closing the debate. I give the floor back to Ms. Urbanova.
Thank you very much. And perhaps just a very short question for the two teams as we wrap up. Over the day 1 to day 3, and also perhaps throughout the course of your studies, are there any areas of law or perhaps particular organizations, international law focuses, or perhaps countries and legal systems that you are interested in learning more about or exploring further down as professionals? And really just a short one. So passing first the floor to Tallinn University of Technology's team.
Hello. So personally, okay, there. So personally, one of the main areas of law I'm interested into is actually Qatar law, because I am from the Philippines. However, I've lived the majority of life in Qatar. So currently I'm going to try to explore both Qatari law and EU law and try to compare the two in their functions and how they regulate everything as a whole.
I think I can make. I'm from Finland originally, and for me, the main subject of interest to me has always been EU law, and maybe some aspects of public international law, but EU law, and especially how EU law regulates things related to the internal market or things related to technology has always been interesting to me. And I'm hoping to learn more about that and kind of stay on that path.
And Mr. Shkiladze?
Right. Then passing the floor to Team Guthan. Perhaps area of law or country's legal system that you are looking forward to learn more about or engage with as professionals.
So, regarding my interests, I would start with the area of law. So, the area of law that I'm most interested in is I am interested in corporate law, but I am passionate about environmental law as well. And regarding the country laws, I would say that for now, the European Union's laws, as well as the laws from Singapore, are the most intriguing ones because they are like closely related to corporate aspects as well and provide, I would say, like world acclaimed legal frameworks for corporate matters.
As for me, while I do believe that corporate law and is quite lucrative, and I would love to be passionate about it, somehow it just doesn't really appeal to me as much as human rights law and criminal law. I've always found these to be particularly interesting to me and something that I get genuinely interested by. But this semester we've been learning administrative law as well, and I found that to be quite interesting and something that I could see myself studying a bit more, maybe. I also find constitutional law very interesting as well. Thank you.
As for me, I find, like my senior mentioned, criminal law and public international law appealing to me. Public international law because ever since I've started participating in moot competitions and this competition, I found that there are so many things to learn about. And as for criminal law, we have just begun studying criminal law in one of my courses. So I found the class very intriguing, and this is why I think these two areas of law appeals more to me. Thank you.
Right. Thank you very much for the two teams. And on behalf of the organization, we really wish you all the best going forward. We look also forward to seeing you at the networking session during the mid-edition break before we announce the results for the next stage. And we really congratulations for wrapping up your group phase. Well done. And we see you at the next moment. Goodbye.
Thank you. Bye-bye.
Thank you, everyone. Bye.
Thank you.